Case Study, Maersk Klaipeda. With Quadraant Legal. Introduction. Imagine paying nearly $500,000 for valuable cargo, only to discover it's nothing but worthless material. Can you sue the shipping company? Or is it your loss? This exact issue came before the English court in the case of Seafarers vs. Maersk K.S., involving the vessel Maersk Klaipeda. This case reshapes how we understand carrier liability and bills of lading. Facts of the case. Let's break down the facts. The claimant agreed to purchase what was described as copper shipped in containers. The shipment was carried by the vessel Maersk Klaipeda. The seller issued documents, including a bill of lading, suggesting legitimate cargo. The buyer paid approximately $459,000. But when the containers arrived, they didn't contain copper, they contained worthless concrete blocks. The legal problem: the fraudster disappeared, so the buyer turned to the carrier, Maersk, and claimed. The carrier issued a clean bill of lading. The weight and description were misleading. The carrier should be responsible. So the key legal issue became: can a carrier be held liable for fraudulent cargo descriptions provided by the shipper? Role of bill of lading. A bill of lading plays a crucial role in shipping. It acts as a receipt for goods, evidence of the contract of carriage, a document of title. But here's the key question: does it guarantee that the cargo inside is exactly what is stated? Legal rules applied. Under international rules like the Hague Rules, the carrier's duty is limited. They must check the apparent condition of goods, record what is visible externally. They are not required to open containers or verify contents inside sealed shipments. The carrier relies on information provided by the shipper. Court's decision. The court ruled in favor of Maersk. It held that the carrier did not misrepresent the cargo. They relied on the shipper's declaration. There was no obligation to verify contents inside containers. Therefore, the carrier was not liable for the loss. Key legal principles. This case establishes important principles. First, carriers are not responsible for hidden fraud inside sealed containers. Second, bills of lading do not guarantee the truth of cargo contents. Third, the risk of fraud often lies with buyers or their due diligence processes. Practical lessons. This case is a warning for traders. Never rely solely on shipping documents. Always verify the seller, the cargo, independent inspection reports, because once fraud happens, recovery can be difficult. Conclusion. To sum it up, the carrier is not an insurer against fraud. A bill of lading is not a guarantee of truth. And in international trade, due diligence is everything. The information provided here is for education purpose only and does not constitute as a legal advice or solicitation. Subscribe and join our community and stay informed. Welcome aboard. Like, share and subscribe.